wanted to provide a California employment law defense attorney's perspective on Governor Cuomo's apology issued to his alleged victims. Now, on March 3rd, 2021, I believe Governor Cuomo made this statement on March 3rd, this apology to his alleged victims. I wanted to address it from a California employment law perspective and from my defense perspective that I bring to defending these types of claims here in California. And I think there's some good lessons that employers could learn. And so I think it's valuable to watch this and take these lessons to heart in terms of these current affairs. A few caveats before I get into the video, the apology. One, we're dealing with a public figure in New York, so public figure, obviously in the public agent context, there's going to be different laws, and also New York law is going to be different than California law. So in generally speaking, I'm going to be applying some very broad, general California employment law sexual harassment issues here in context of this apology. So with that said, let's jump right into it.
I want to address the recent allegations that have been made against me. As you probably know, the Attorney General is doing an independent review, and I will fully cooperate with that review.
No, that's great. The independent review, the investigation has to be done under California law. Employers have an obligation to investigate all complaints of sexual harassment. Failure to do so could actually be a cause of action. Failure to investigate and correct any harassment that the employer knew or should have known was happening in the workplace.
Now, the lawyers say I shouldn't say anything when you have a pending review until that review is over. I understand that. I'm a lawyer too. But
so, yeah, generally speaking, that's great advice. Employers should not start making any kind of statements internally to anybody else in the company, and even especially externally outside of the company about any alleged harassment claims or investigations into it or anything like that. They need to get all the facts first, do the full investigation before it's addressed. I think that's a great piece of advice. And again, I think because Governor Cuomo is a public figure, has to be out in front of it and address it. I think there's different motivations coming into play here as a public figure.
I want New Yorkers to hear from me directly on this. First, I fully support a woman's right to come forward. And I think it should be encouraged in every way. I now understand that I acted in a way that made people feel uncomfortable. It was unintentional, and I truly and deeply apologize for it.
Okay, so now under California law, it doesn't matter if the alleged perpetrator intended the action or not. What's important is the victims. We're going to look at the victim and the victim's perspective on whether the victim felt that it was harassment or whether the victim felt offended by the conduct. Now here in this scenario, there's an argument that this could be quid pro quo sexual harassment, this for that, a threat that if the women didn't go along with the sexual advances, they would be terminated, demoted, or something like that. But here, I haven't heard of any facts that there was any adverse employment action against the women. So we're probably under a hostile work environment analysis here. And for a prima facie case of hostile work environment, sexual harassment under California law, the plaintiff has to show that she was subjected to unwelcome sexual advances, conduct, or comments. 2, the harassment complained of was based on sex. And 3, the harassment was so severe or pervasive that it altered the conditions of the victim's employment and created an abusive working environment. And so here you're going to look at the plaintiff's perspective, and looking at the plaintiff's perspective, there's a subjective element to it and an objective element. The objective element, you're looking at a reasonable person in the victim's in their shoes, would they have thought that this was harassment or offending conduct? And two, you're going to look at the subjective aspect too. Did the victim subjectively in this scenario, did they feel that they were being harassed or this was offensive conduct? So we're looking at the victim's perspective. It doesn't really matter what the alleged perpetrator thought or intended.
I feel awful about it, and frankly, I am embarrassed by it. And that's not easy to say, but that's the truth. But this is what I want you to know, and I want you to know this from me directly. I never touched anyone inappropriately. I never touched anyone inappropriately. I never...
Okay, so under California law, does there have to be physical touching for there to be sexual harassment? And the law is quite clear that no, there does not have to be a physical touching. So it's not relevant that there was no touching ever. Sexual harassment can come in many forms. It can come verbally, comments made to somebody over a period of time. But again, it's so severe or pervasive. Conduct statements that could meet that standard. Courts have actually held people staring at other people over the course of time has been enough to be sexual harassment in the workplace. So it's not relevant that there was no touching.
I never knew at the time that I was making anyone feel uncomfortable. I never knew at the time I was making anyone feel uncomfortable. And I certainly never, ever meant to offend anyone or hurt anyone or cause anyone any pain. That is the last thing I would ever want to do.
And again, in terms of sexual harassment analysis, whether his intent was there or not, it's not relevant for the legal analysis for sexual harassment under California law. We're really looking at the victim's perspective.
I ask the people of this state to wait for the facts from the Attorney General's report before forming an opinion. Get the facts, please, before forming an opinion. And the Attorney General is doing that review. I will fully cooperate with it, and then you will have the facts. And make a decision when you know the facts.
And that's a great way to end the video. Again, kind of harkening back to that first point. I mean, get all the facts, do the full investigation. Nobody should be jumping to any kind of conclusions before all the witnesses are spoken to and all the facts are gathered. So it's a great point, great reminder, and that is true. And employers need to be careful about jumping to any conclusions before the full investigation and all facts are known when conducting a workplace investigation and working through an allegation of sexual harassment in the workplace. So I hope these pointers help and we can all learn something from these current affairs in terms of sexual harassment in the workplace. If you have any questions or comments, please let us know in the comments section below. Thanks for watching.